back to Aging, Healthcare, and Everything in Between, where we talk about things that help families live well through their retirement years. And I'm your host, Stephanie Pogue. Today, we are talking to Court Smith. He's an estate planning attorney and the owner of Smith Estates and Trusts. So thank you for coming on the show today.
Thank you for having me.
Yeah. So first, I want to say I've talked to a lot of estate attorneys throughout the years, just in my profession, and then also going through the process with my dad and my disabled sister. But when we were talking a few weeks ago, you had all kinds of ideas, misconceptions, concepts that I had never really heard before or thought about in detail. And so I thought, today, I think that's why we decided let's talk about the misconceptions around estate planning, all those maybe sometimes big things, but a lot of times the small things you don't think about that can be a huge hassle later. Ready?
Yeah, I'd be happy to. Yeah, well, thanks again for having me. In my practice, I've practiced for 18 years, and primarily I do estate planning. I also do probate and trust administration, but I've met with a lot of clients over the years, and you start to see a kind of a pattern of misconceptions that they come into the meeting with. And so when I talk to people about estate planning, especially in this kind of a context, it's easy to talk about it from a standpoint of misconceptions. Like basically, let's find out where we're wrong about things and correct them. And I think that's a good place to start. So I've got 10 of those for you today, and I'm ready whenever you are.
All right, 10 misconceptions. Perfect. Where do you want to start?
Well, I'd just start with wills and probate. I think that those are something that people are familiar with, but don't know exactly how that process works. And there are some very strong misconceptions in that area. And the first misconception that I hear all the time is that probate is where the government takes your money. It's this idea that there's this organization called Probate, and they're there to take your estate, your money. But nothing can be further from the truth. So what is probate? Probate refers to a division of every circuit court. So here I'm sitting in St. Charles County. The courthouse is basically outside my window here. Inside that courthouse is a division called probate, just like you have a criminal division. And probate handles matters of decedents, so like estates, as well as guardianship matters. And so when you say the term probate, you're basically referring to a court process. And so does the government take your money in probate? No. Maybe there's a small filing fee, but really I think the reason people try to avoid probate is because of the cost to pay the attorney, which is based on a percentage of the estate, the fact that it's a very public process and open to anyone to see. But when you think about probate, it really is it's a court process. It's nothing more than that.
Yeah, I hear what you're saying, because a lot of people will say, I want to avoid probate. I don't know what that means necessarily, but I want to avoid it.
Right.
Yeah, I get that.
Yeah, it's a self-perpetuating thing that everyone wants to avoid it. And to be honest with you, someone who's practiced in probate and handled probably 1,000 or more probate estates, it's really, it gets a bad rap. It's really it's a very transparent process, but I do understand there's better ways to do it. And that's what we'll be talking about today too.
Yes, we went through it with my dad, and it was smooth enough, but it took a long time, and fees add up, and where you just want to get it done. So how do we avoid probate, or do we have to avoid probate? Tell me more.
Well, the goal is always still to avoid probate, but so my second misconception is that a last will and testament avoids probate. And my reaction to that is always, a will does not avoid probate. A will is probate, meaning that a will only has authority when it's been filed with the probate court after someone has died, and it only controls assets that are subject to probate. So the idea of a will avoiding probate couldn't be further from the truth. It is probate. And so that's the only place that that document has any authority. So how do you avoid probate these days? And the primary way is by non-probate transfers, which is a fancy word that means things that we all know about. For example, beneficiary designations. These include transfer on death, or TOD, for cars. A lot of people are familiar with this, and if you're not, you should know that in the Missouri Department of Revenue, at the DMV, you can add a individual as a beneficiary on your car. So that is an example of a non-probate transfer. Similarly, your bank accounts have POD, payable on death, designations. And those are also available on life insurance, IRAs, 401ks. Another non-probate transfer is when you own something as a joint owner. For example, a husband and wife may own a joint bank account. When one spouse passes, that account goes directly to the other. So, and in Missouri, we're very lucky to have what's called beneficiary deeds, or also known as transfer on death deeds. And they allow us to put beneficiaries on our real estate as well. Okay. So those are examples. That mechanic of non-probate transfers is the ticket to everything estate planning. And by having any of those, you avoid probate on that particular asset.
Okay. When people say, I don't need a will or a trust because I have beneficiaries on all of my IRAs and 401ks, my child is on my bank account, I have TOD on all my cars, I don't need it. Is that true, or is that a misconception?
That's a misconception, in my opinion. Yes, you may get away with it, I'll say that. But I would always recommend a will. We'll talk about other things you may need, but in all cases, it's best to have a will. And even in a trust scenario, you still have a will. And the reason why is that something can always fall through the cracks. The best example of that is a tax refund. Okay. If you receive a tax refund, let's say it comes in the mail the day after you pass or a week after you pass, it says to John Doe, there is no way, well, there may be some ways, but there is no
easy way,
appropriate way to get that check into a bank account that is already paid to a beneficiary. So that's a great example of something that even the best planner can't avoid. And so having a will that reflects your intent, whether that will leaves your assets to a trust or to the beneficiaries you want, is still very important.
Okay, I could see that. We had my mother-in-law was living in an assisted living facility, and she already paid the rent for the following month and then passed away. Well, we couldn't get that check back because she had already, we weren't on her accounts and all that. So a will would have helped in that.
Right. That's
situation.
Right.
Gotcha.
Yeah, and wills provide, so when you have a properly drafted will, it benefits or improves the experience of probate in a way for a couple of big reasons. First of all, you are naming the person that you want to be your personal representative, which is, in Missouri, that's the term you would think of as executor. And so first of all, you're avoiding a fight about who would be in charge by naming a succession of your personal representatives. Secondly, it allows you to waive bond. And bond is like the requirement that you have to pay insurance to administer an estate. The idea being that this individual doesn't run off with the money. So you waive bond because you trust your family, you trust whoever you've named not to take the money to Vegas or whatever. And then the third benefit of a will is the ability to elect independent administration as opposed to supervised administration. Supervised is very difficult. That creates a lot of difficulties, requiring a lot more court approvals throughout. So wills have a lot of bells and whistles in them that make the probate process easier.
All right, I know I've spent a ton of time on wills here. What about trusts?
That's a great question. So you just led me to misconception number 3, and that is that you have to have a trust to avoid probate. We just talked about non-probate transfers and wills. So this misconception can infer is not true, because you can avoid probate in Missouri without having a trust. And we talked about why. We've got PODs, TODs, beneficiary deeds, and that's the key. So when your audience is Googling matters of estate planning, be mindful that you may be getting answers from other states as well. For example, Illinois, for the longest time, never had beneficiary deeds or transfer on death deeds. So in Illinois, prior to some more recent statutes, in order to avoid probate, you had to have a trust, because you had to put the real estate in the trust before death to pass over probate. In Missouri, you don't have that issue. So you can avoid probate in Missouri without a trust. And that's not, I'm not saying that trusts are, that's a reason to avoid trust, but it is a fact that in Missouri, there's no assets that you cannot put some kind of a beneficiary on.
Yeah, that's good to know. A lot of people think they have to have a trust, but you don't necessarily. Okay.
Right. And then another misconception, so I'll call this number 4, is that having a trust means nothing will go to probate. There's this idea out there that somehow if I sign a trust, it automatically brings in all of my assets just by virtue of signing a document. And I think bad estate planning attorneys, or bad estate planning embodies this misconception. And that is that you've created a trust, but no one's telling you, okay, now that you have the trust, you need to fund the trust properly. And so you'll walk out with a fancy 3-ring binder set and think you're fine. But a trust is not a magnet. It's not a vacuum. You can't walk into the bank and say, oh, my dad had a trust, so this bank account should be part of it. No, you need to direct things into the trust properly by beneficiary designations or by lifetime transfer. So the other important thing, to not feel that just by having a trust, you've avoided probate. That's not the thing that avoids probate. It's the non-probate transfers and other things we talked about.
Yes. So going to the attorney, and great, you have a trust set up, but if you don't go home and change the beneficiaries on all of your stuff to either go to the trust or whoever else, it doesn't matter, right?
Right. That's correct. Okay. That's very well characterized, yes.
Okay.
And
then anything else about trust that we have to know?
Yes, got a couple more for you. The 5th misconception is that a trust is always superior to a will. The first question a lot of clients will ask me is, what's better, a will or a trust? Well, they're really completely, they're distinct. It's not a one or the other. You always need to have a will. Even if you have a trust, you will have a will, which we call a pour-over will. And that is the idea that the will pours into the trust. Okay, so if something were to inadvertently go to probate, your will acts as a safety net to grab that asset and put it into the trust where you have your beneficiaries lined out. So, okay. But with that being said, a will is always a necessity for just a basic estate plan, in my opinion. But do you always need a trust? And for me, I say why. My question to clients that we explore is, why trust? A trust I describe as a Swiss Army knife. It's got all these cool tools and you can do a lot of great things, but identify the why. And there are a lot of whys. In fact, it's not that often we don't find a why. And what are the whys? The whys are, do you have minor children or minor beneficiaries? You need a trust so you can dictate ages of distribution. Do you have many beneficiaries? Because if you have 4 children, putting them on a beneficiary deed for the house is not a good idea. Too many cooks in the kitchen. Okay. Yes. Do you have a child or a beneficiary with special needs? Do you have a farm or some kind of recreational property you want to hold for a generation? These are all, there's a lot of reasons why, but there are scenarios for individuals and couples where let's say they have 1 or 2 children. A trust may not be necessary. Simple beneficiary designations and a beneficiary deed on the house may be adequate.
Figuring out why you need the trust would to determine if you even need one or not.
Right. Yeah. And like I said, I mean, when you start to dig, there's a lot, you often will find a why, and I enjoy when you don't find the why and you can do a more simple plan for somebody. Why overthink it, so.
Yeah. Yes. Yeah. So I hear a lot of not a lot of estate planning attorneys, but there are a lot of attorneys out there who do Medicaid planning. And I know that involves a trust. Tell me more about that.
Well, that's a great lead into my next misconception. And that is that, having a trust somehow allows you to automatically get Mo Health Net benefits, which is Medicaid in Missouri. Somehow that by having a trust, those assets are not counted towards qualifying for Medicaid. And that is dangerous misconception. Most trusts, and the trusts that I prepare for clients, are revocable trusts. So while you are alive, for all intents and purposes, you still own the assets, even if they're in your trust. For example, you report them under your Social Security number. So by having those assets in your trust, it's impossible to go to the state of Missouri and say, look, I don't own these assets. You do own them. So the type of trusts that are employed by elder law and Medicaid attorneys are very specific, irrevocable trusts where you lose most, if not all, of your rights in the assets. So very distinguishable, and I would recommend anyone that is interested in looking into those that they find a reputable elder law and Medicaid attorney that specializes in that. But I will say, remember, you don't get something for nothing. So if it was as easy as just putting an asset into a can and saying, oh, I don't own this anymore, we would all do it, and the Medicaid system would be would be bankrupt.
So there are two different types of, there are a lot of different types of trust, but for this purpose, there are definitely two. And just having a regular revocable trust does not stop Medicaid.
Correct.
Does not get you. Okay.
Yeah. Now, along the same lines, my seventh misconception would be about having a trust somehow avoids creditors being able to get at your assets. And it's the same analysis as Medicaid. If it's your trust, it's still your money. It's a revocable trust. It's different for your beneficiaries. They would have some protection, but not you yourself, unless it's a very, very specific type of trust. And some would argue that in Missouri, there really are no true asset protection trusts that automatically protect you from creditors. So still have to drive safe, still have to, negotiate with your neighbors, in good faith if you
Yes.
have a revocable trust. So, yeah.
So the trust is setting it up for when you pass away, but it's really not going to protect anything right now.
Correct. Mm-hmm.
At least from creditors. Well, that has all been really good information. What's another misconception that people have?
Well, finally, thank you. Finally, I'd like to talk about powers of attorney, which, in my opinion, in a lot of cases, may be more important than any of the other documents we've discussed. And that is because with powers of attorney, when you need them, it's too late to get them.
Yes.
And so my first misconception about powers of attorney is I don't need a financial power of attorney because I have my son or daughter on my bank account with me. Okay. A little bit of like self-help estate planning, which I admit in some instances there are benefits to having someone else on your bank account, but there's also a lot of pitfalls to doing that. And one of those is that, let's say you have 3 children, but you put 1 child on the bank account. When you pass, that bank account becomes that one child's account. They have ownership of it. that creates potential tension between the other children as to whether or not that was mom or dad's intent, or if there was something, nefarious going on. So to be cautious about that. But there are many other reasons why you would need a financial power of attorney. And for example, well, a big example is the need to sell a home if you were incapacitated, or your car. And simple things like the ability to cancel a utility or even speak to a utility company on behalf of your parent. And sometimes when a spouse loses their spouse, you have a situation where the surviving spouse never handled the books, never was able to balance the check. And having a financial power of attorney with a trusted child or a friend or relative on it can act as, give someone official capacity to assist you with things like paying your bills or communicating with your financial advisor. And I will note, financial powers of attorney, I typically draft them so that they are effective immediately. Healthcare powers of attorney, which we'll talk about in a minute, you have to be declared incapacitated by a doctor. For financial, that's an option on if you draft it that way. And I've always preferred drafting it as that's effective immediately, with my rationale being, if you don't trust the person now, why would you trust them when you're incapacitated? But also the reality is that no one ever becomes, well, maybe some people do, but most time incapacity doesn't happen overnight, or a diminished capacity. It could be a slow process, and you may need gradual help with things. And so having a financial power of attorney that can do all of these different financial roles is very important.
I could see that for sure. I get a lot of calls from kids who are trying to now take care of their parents, and maybe if they haven't had a long-term care plan set in place or something like that, and they're to the point now, well, I need to start cashing out IRAs for my parents, or I need to sell the house. Again, even calling to cancel utilities, they would not be able to do, or would be difficult to do without the financial power of attorney, right?
Correct. Absolutely. Remember, the alternative to powers of attorney is guardianship and conservatorship in the probate court. And these are very difficult situations, even in the best families, because we're talking about the petitioner, the child having an attorney. An attorney is appointed to represent the parent who has diminished capacity. You have a court hearing. Any assets that are subject to a conservatorship are strictly controlled by the courts, requiring hearings and motions in order to use the money. And so that's why I believe that powers of attorney in a lot of cases are extremely important, if not more important than any other type of estate planning. If I was forced to, if a client said, I'm only going to do one of these documents you're recommending, there's a good chance it may be one of the powers of attorney or both the powers of attorney. So, and speaking of the other power of attorney, so powers, you always distinguish healthcare and financial powers of attorney. I've seen a few instances where those are smashed together in one document, but typically they're almost always separate. And you can imagine there's a lot of good reasons why. Your bank doesn't need to know who's making your healthcare decisions. Your doctor doesn't need to know who's making your financial decisions. But a common misconception about healthcare that I hear is that I'm a married person, and so my spouse has the right to make medical decisions for me. That's not true in Missouri. There is no law that creates some kind of a hierarchy for who can make medical decisions for you. Now, thankfully,
that's so important to know.
It is very. And I've had doctors as clients who thought the law was that a spouse had that right. So whether that's good or bad, I don't know. But you could. I will say this: hospitals can be pretty caring or sensitive where I don't ever get the impression they're ever trying to put up a wall about making decisions. So, but the reality is, when push comes to shove, there is no law that says I have the right to make medical decisions for my spouse or to know what's in their medical record, which is the HIPAA law. And so with that being said, everyone should have a healthcare power of attorney, naming those people in the order that they would like to have make those decisions for them. And very rare, I always try to recommend to clients to keep things singular, meaning you name one person and then a backup and then maybe another backup. Of all the different types of documents, the one document that I think it's safer to name more than one at the top would be the healthcare power of attorney, where you might name your spouse and a child or two of your children. But otherwise, I would recommend that it stays singular in succession. But powers of attorney are very important. The healthcare power of attorney these days typically also contains a healthcare directive, which used to be known as a living will, and now has kind of evolved into a healthcare directive. And so make sure that whenever you're preparing one of these, that you have both parts of that instrument. So healthcare power of attorney, who makes decision, healthcare directive, what you would allow to be withheld or withdrawn if you're in a persistent vegetative state.
Okay, yeah, I didn't realize that there were two separate ones. Again, good information. Do you have, is there 10? There's a last
Yeah, that was
final
number
misconception?
9. Yeah, I got 10 for you. And this was actually number
All right.
1. I put it to the bottom because it's got some punch. But so my 10th misconception is that estate planning is for the rich. And that estate planning is any step that you take to control what happens upon your death or incapacity. Every little thing, putting a POD on a bank account, going to the Missouri Bar website and downloading their healthcare power of attorney and directive and having that executed, which is excellent, by the way. So estate planning is not something to be intimidated about. Almost all of my clients comment on how easy the process is. I would much rather do an estate plan than do my annual tax returns any day, for anybody. And so I would encourage anyone out there that doesn't have wills and powers of attorney or a trust, if needed, to contact a local estate planning attorney and give that peace of mind to yourself and to your loved ones.
Okay. And so, and I was taking notes as you were talking today too, because I thought it was really great information. What I got out of it is that everybody needs a will. Sometimes you need a trust, sometimes you don't. Everybody needs, especially as we get older, financial power of attorney, healthcare power of attorney, and a healthcare directive.
Correct.
Is that okay? And then put beneficiaries on everything that you possibly can, right?
Yes.
And look up beneficiary deeds, especially in Missouri for real estate.
Right. But be cautious if you have more than 2 beneficiaries. Beneficiary deeds doesn't seem like it, but I can tell you that there's a lot of potential issues with that. So
Sure,
that's where a trust would become helpful. But, yeah.
Okay. And then sometimes we need a trust. Is that kind of covers it, sums it up?
Yeah, that covers it. Yeah.
Well, thank you. I think that was incredibly good information. And I think for anyone listening, if you're not sure where you stand, you don't have to have all the answers today, but you do have to start asking the questions. So find a reputable elder care attorney or estate planning attorney in your area. And I'm sure that Court would be able to help you, be happy to help you as well. But I hope you enjoyed the information today and you found it helpful. And I look forward to our next episode. Thanks for listening to another edition of the Aging, Healthcare, and Everything in Between podcast. Please share this podcast so that others can benefit from the content. Please also leave reviews, as feedback is important to me. And if you have any suggestions for a future episode, email them to s.pogue@stlouisinsurancegroup.com. Thanks again for listening, and I look forward to bringing you more valuable content soon.